It is July 14th of 2026, and this is the Court Gallery. Coming up, we begin with Judge Stewart in Corunna, Michigan. He is not impressed when a lawyer's expert pediatrician gives an opinion without ever speaking to the father or the child. Then we join Judge MOGEN's courtroom, where one man learns that I don't have any way to pay isn't a valid legal strategy after 7 years of dodging a $200 fine. And finally, a woman who brings her own unique interpretation of the law to court gets an unexpected lesson from Judge PERKINS on how the system actually works and walks away with a plea deal, an earful of advice, and a big book of laws. All that and more starts right now.
Mr. Homola, court will take up the next matter of 261741DC. Mr. Homola and Ms. Lathrop Roberts is here as well. And that matter is captioned Ulrich versus, is it Geisler?
Yes.
Geisler, very good. So we do have Mr. Homola, attorney for Mr. Travis Ulrich. And please, folks, have a seat. Attorney Lathrop Roberts is here on behalf of her client, Ms. Geisler. This is a custody matter. The court on June 4th of the year 2026 had signed a proposed order generated during a Fig C conference. That order granted the defendant mother primary physical custody, the parties shared legal custody, and there was a parenting time schedule granted to father. Mother objects to that parenting time schedule and asks the court, in addition to consideration of the objection, to order that Mr. Ulrich pay attorney fees to Ms. Geisler as well. So I've read the motion, I've read the objection, I've read the response filed by Mr. Homola. This will be argument only. Ms. Geisler, or Ms. Lathrop Roberts, I'm ready to hear your argument.
Thank you, Judge. Well, thank
I'll
you.
need you at the podium, though, just because it's closest to the microphone. Yeah, thank you.
Can you see me behind it?
I can see you behind it. Yep.
All right. Well, I agree with your recitation of the facts in this case. We have a 2-year-old child who is, my client would testify, a very strong-willed child going through a developmental stage where she's very clingy and needy of her mother's attention at all times. And my client, I believe, conveyed that to the conciliator. And so my client is complying with the temporary order that's in place.
Well, I'm glad to hear that she's complying with an order of the court.
Oh, yes. Well, it has not been without its challenge and difficulties, and she would tell you that as well. So we consulted with the state court administrator's office with the parenting time guideline. And with a child of this age, the suggestion is to keep the overnights to 2 consecutive overnights, so that the child is not separated for too long a period from the primary caregiver. The quote is, parents may consider limiting overnight parenting time to 2 consecutive nights to minimize the time away from the other parent. So my client's request is to not to address the child support in any matter, but to ultimately alternate the weekends from Friday night to Sunday night, and to work up to that parenting time as proposed, so that Mr. Ulrich would have the parenting time Friday to Saturday, and then a midweek parenting time on the off weeks for a period of 3 months, and then expand his parenting time to alternating weekends from Friday to Sunday evening thereafter, with the idea being that the child will have more frequent contact with Mr. Ulrich, because she will be seeing him during the week, every week, and that she will have time to adjust to this change in her routine and her family structure. And my client did consult with her pediatrician, and the pediatrician made some recommendations, and my client would testify. The recommendation was to gradually work up to the parenting time.
Did the pediatrician consult with father before these recommendations were made?
No.
Why not?
Well,
I mean, parties have legal custody, right? Both legal custody. What kind of expert would make an opinion without consulting the other side?
well, I'm telling you that was the advice given by the pediatrician to my client.
But based on input only from your client, not from dad, right?
That is true.
Seems kind of biased to me.
Well, let me say, we have a short window of time in which to do this, to work this all up.
But certainly you could have called Mr. Ulrich, and he could have had some input too before the pediatrician made his or her recommendations, right? Certainly had to be more valid to me.
Well, yes, that's true. Mr. Ulrich is aware, I think, that the child did go, that the pediatrician did offer some advice. The child was seen by the pediatrician. And Mr. Ulrich was not involved in that assessment.
But did he know that there was going to be an assessment and a recommendation rather than just treatment? And it seems to me that if the child was going to be assessed and being examined, that he should have given an approval for that because the parties have legal custody.
It was not a formal assessment.
But you've just represented that the pediatrician made some recommendations.
Yes, that's true. But he didn't observe the child. It wasn't a full-blown assessment.
So he made recommendations without observing the child?
That's my understanding.
So the pediatrician made a recommendation based solely on your client's input, correct?
That's true.
Does that seem fair to you? Really? Does that just?
Well, let me just say this. For purposes of this is, we are attempting to address an interim problem. If we have a full-blown hearing, we would have a thorough workup.
So it could be a less of following protocols because it's an interim order?
You know, my off-the-cuff response to your question is a good question.
Thank you.
Is yes, because.
Does it make it less fair because it's an interim order?
Here's the problem with anything that results from a conciliation. There's no record of statements that are made, evidence that's.
Well, it's an ex parte order, you see.
Yeah, and so anybody who wants to defend what happened or wants to challenge what happened as a result of the conciliation is at a disadvantage. So I guess professionally, my approach has been to try and raise the issues that I don't feel were addressed in the conciliation. And again,
Okay.
it's an informal process, makes it a challenge for attorneys to try and tease out what the appropriate order really is. So you are correct. I agree with the court that if this were to be if we were going to offer this pediatrician to testify here today, Mr. Ulrich should be involved in that if he chose to. But we're not offering the pediatrician here today. I was just indicating to the court that my client had some backup for her concerns about how the parenting time is going and how this is affecting her 2-year-old. So my client wants the best for her child. My client wants her to have a good relationship with her father. my client would testify that the child is distraught, acting out, and carries on when the parenting time exchange happens. We're all aware that some of that goes with the territory, with children, younger children or older children, but the question for a parent always is, how much is what is okay and what is no longer okay? At what point in time is this a bad thing for my child? So my client has requested at the conciliation, and I think she's also spoken with Mr. Ulrich, they're trying to work this out and get along. She wants something that's more gradual. So she knows her daughter is okay. Not that she's trying to interfere with that relationship, but she wants to know her daughter doesn't have some sort of traumatic event every time it's time for parenting time with her dad, because that's not good for dad's parenting time. She wants her daughter to have a good relationship with her father. She just doesn't want, this was a very sudden change in this child's routine. And it's 3 long weekends every month. And my client's expectation is that her daughter will grow out of this. It's a developmental stage as far as my client's concerned, but she wants to accommodate it. So our request is that, and in addition, our position also is that 3 overnights, 3 times a month is not really appropriate for a child of this age. And she would prefer that the parties alternate the weekends and then it be kind of the typical parenting time of Friday night to Sunday night.
I mean, a typical non-custodial parenting time arrangement.
Yes.
Okay.
Yeah. And I would say, we are talking, I recognize we're talking about a temporary order.
Yes, that is correct.
So we're going to do something. I hope, we will all collaborate and come up with a kind of a comprehensive parenting time. But while we're kind of in the thick of all this and trying to figure things out, our request is that we pull back a little bit and go a little bit slower.
Very well then. Ma'am, would you like to make your argument with respect to attorney fees while you're up there?
Yes, I would. The conciliator imputed income to my client. My client had to leave work during her pregnancy because of illness. She had gestational diabetes, and she has not worked since. And she would testify to the court that was, in fact, by agreement of the parties, that Mr. Ulrich's position was he didn't want the child in daycare. And so the parties agreed that she would not work, she would stay home and take care of their child. So at this point in time, my client has no income. She is able to work occasionally with her stepfather doing painting, but that is, it's not a 9 to 5, there's no guarantee of the hours. And so she had to borrow the money to pay for my retainer fee. And so at this point in time, she's unable to afford the expenses of this litigation. And our position is that Mr. Ulrich is in fact able to pay for her attorney fees. And I did some quick math. I used the conciliators or the front of the court's worksheet for incomes, and reflects that Mr. Ulrich, by the time he pays all of his bills, has about $450 left over every month. So our request would be that the court fashion some remedy whereby my client's attorney fees would ultimately be paid by Mr. Ulrich.
In the amount of?
$2,000.
Okay. Thank you very much.
Thank you.
Mr. Homola, your response on both issues.
In regards to the objection to the temporary order, I believe that the front of the court, Ms. Akers, made the best of the situation. Father had an established bond with the child. Mom refused to allow any parenting time. There was a lot of lost interaction. However, While there were some obstacles at first, Ellen would appear, upset during the transition for the pairing time. That has, while there still is some indication of it, father believed that mom could have, promoted the exchange a little bit more. I'm not saying there's coddling going on, but the behavior on the transition for a 2-year-old, things are much better. My client says that, hey, at first, yes, there's issues, they work together on it, but if she is visibly upset at first, with 5 minutes or less, it stops, and they have a wonderful, parenting time for the remainder. There's never any instances that come up during his parenting time. This is very minimal. I mean, I think what Ms. Akers did was to, enhance and promote the current bond that Ellen had with father. I think this is a great stab at it. It's a temporary order. We think it's in the best interest of the child. My client would testify that he wants more time, but this is a temporary order. He didn't object. But I think, given the circumstances, this allows for interaction. I don't agree with the, beyond 2 overnights, argument. I haven't seen any studies of that effect, and I've had many cases where the opposite is true. As far as the time with both parents, not that, one overnight in, extended duration. In fact, I believe and would submit it's more beneficial to the child. There's a strong bond relationship. It's continued with this current order. Father is hopeful that they can work something out for expanded parenting time. We had some obstacles, obviously his employment, work hours, mom's not working, but we would ask that on a temporary basis that this continue. There's one instance of a diaper rash. My client claims, hey, I didn't see anything in regards to any diaper rash. So he's, still doing what he was doing, but just making sure in the middle of the night, check the diaper, even if, there's concerns or, that because of on the one occasion that occurred. Beyond that, this current order is in the best interest of Ellen. It allows father, some interaction with the child, and it's minimal compared to what he was getting before the separation, and he's grateful for it. And I think Ellen is doing very well with it, according to my client. In regards to the attorney fees, we laid out my client's budget. What's not in there is his own attorney fees. He has a legal right to establish, custody and parenting time and all of those things because the parties were unable to agree. But he's got his hands full paying for my services in relation to this. It appears that, we're hopeful that the parties can come to an agreement as far as, a final order in this matter. But on a temporary basis, she has counsel. He's struggling on his end as far as his fees. By his own budget, he's got, $400 extra, which I think he's been paying to my office to catch up. I had worked with him on that. Mom's also receiving about $10,000 a year, $819 a month for one child. That's pretty significant.
831.
Even under these current guidelines, which seem to have been, depending on who you're representing. But I'd ask that the objection be denied. I don't think on a temporary basis that this is so out of whack that it needs any adjustment. Ellen's doing well, enjoying her parenting time with father. The exchanges are going well. As soon as Ellen adjusts, she's smiling, she's happy. They have wonderful parenting time under this order. The attorney fees we'd ask to be denied. Not only the ability to pay, because what's not in there is his own costs for attorney fees, but this is not a divorce action. They both have a right to counsel, but it's whether or not he, has to submit monies and pay for her attorney fees. I don't think it's called for. Thank you.
Thank you, Mr. Hamola. The court's ready to rule then on the two issues there before the court today. First would be the objection to the Fig C order that the court signed on June 4th of the year 2026. The recommendation was that father be given parenting time the first, second, fourth weekend, Friday to Monday morning. Mother objects. Two reasons. Number one, the child's pediatrician said it might not be a good idea to have these overnights in a row. Secondly, counsel relies on the State Court Administrative Office Michigan Parenting Time Guideline. With respect to the former pediatrician who did not observe the child or talk to the plaintiff, really doesn't have a lot of credibility with me. I don't know who this person is. Maybe a very nice person, maybe not. Don't know, but if I was going to receive a recommendation from a pediatrician, I would have expected that they'd observe the child and talk to both parties, right? And that would be fair. And with respect to the Michigan Parenting Time Guideline, I did review some of that, and it's my understanding that the purpose of the Michigan Parenting Time Guideline is to help provide a resource to parents that want to come to an agreement, and helps parents create a parenting time schedule. Parents could use the guidelines when it's trying to establish a parenting time schedule that works based on the family's unique dynamics, concerns, and issues. And it says pretty much at the beginning of the document, it does not constitute recommendations from the Michigan Supreme Court. So it is a pretty valuable tool, but mainly used for the parties, not as a binding authority on this court. So what I am hearing outside of those two issues is that you got a 2-year-old that's fussing, going back and forth to mom and dad's. Well, guess what? That's two. That happens. I think the child will recover. I don't have any concerns with the schedule. I think it's a pretty fair schedule. The objection is overruled. Moving to the issue of attorney fees, Mr. Amola provided a budget, which I always appreciate in spousal support cases and attorney fee cases, and Mr. Hamola knows this. I don't have a budget from the defendant. I don't know what her needs are. I don't know what her bills are. I don't know what she pays, but I do know she's about to get almost $900 a month in child support. I know that she left in early April of 2026, left dad with a home and all the bills, so he has to pay for all that. In his motion, he said he had to replace the things that mom took, the child's clothes and toys and things like that. He's got to replace that. He might have a couple of dollars left over every month, but I don't know what mom's needs are. I know that her claim is that Mr. Ulrich didn't want her to work, but guess what? He's out of the picture as of April. I'd expected her to have looked for work or found work in the last 3.5 months. She hasn't. So the request for attorney fees is denied. Ms. Lathrop Roberts, if you would kindly prepare an order to reflect the court's rulings, I would appreciate it. Thank you so much. And if there's a need for an evidentiary hearing down the road on these issues, you'll have a scheduling order, and we'll get together to address those if we have to. Thank you all so much.
Thank you, Your Honor.
Anywho, we're all ready to go. We will go on the record in the matter 25 CF41, State of Wisconsin versus Heather Honeycutt. The state appears through District Attorney Kevin Schmidt in person. Ms. Honeycutt appears by video conferencing from Tachita Women's Correctional Facility. We have Tripp Stroud, her defense counsel, also by video. We're set today in this matter for the restitution argument portion. We went through and were able to complete the hearing and all evidence as it related to the restitution. However, we ran out of time and therefore needed to set a second argument portion. Ms. Honeycutt wished at the last hearing to be transported to Cheetah Women's Correctional Facility and not stay in Burnett County Jail. And she wished to appear by video conferencing at this hearing. Is that correct, Ms. Honeycutt?
Yes, Your Honor.
If at any time you have any questions or concerns and you need to speak with your attorney, let me know and I can send you into a confidential breakout session, okay?
Okay.
All right. Mr. Schmidt, I did receive your argument on the restitution matter. I've reviewed it. I've made notes. However, for the record, please present to the court what you would like me to consider.
If you recall at the last hearing, I want to do my argument in writing and Attorney Stroud wanted to do it
I
verbally.
did, but I was just asking politely if you wanted to say anything on the record.
Nothing additional other than my written argument.
Okay. Mr. Stroud, I'm going to presume you read it. I believe it came through yesterday afternoon, but I can't recall. No, it came on July 10th. You have the floor.
Thank you, Judge. You may recall during the sentencing hearing, I said that this case really should have been tried, and I think that the restitution hearing shows why. The state has the burden of proof by the preponderance of evidence to establish the amount of restitution and the basis for the restitution. And the evidence after almost 4 hours of testimony was a complete quagmire. This is Exhibit 4, Judge. I'm holding Exhibit 4. I'm going to reference Exhibit 4.
I have it here.
Remember, this exhibit came in during I don't know if you want to call it rebuttal, but Mr. Fry was recalled at the end of the hearing. Do you remember that?
I do.
He was motioning in the back. He said, oh, and you said he probably has the list of property that he made in the valuation that Mr. Otto prepared back in 2016 or 2024. And sure enough, it was the list. That's Exhibit 4. This is the list of property that Mr. Fry claimed had been taken. This was the list that he brought to Mr. Otto to value. Mr. Otto dated it March 19th, 2024, and then signed it on the second page. And the total value of property that was submitted to Mr. Otto and that he put his signature to was $44,350.21. Now, what is missing from Exhibit 4?
Are you asking me?
Rhetorically, I'll answer the question. There's no list. There's no silver maple leaf coins on Exhibit 4. There's no gold South African pirate coins on here. None of that. Where does that appear? In Exhibit 2. In Exhibit 2, magically in March of 2024, Mr. Otto says these are the coins. It's at the top of the list. Property that the state is claiming is worth, the gold Krugerrand coins collectively are worth $101,000. The gold Canadian maple leaf coins they're saying are worth almost $56,000. But here we have in Exhibit 4 the list that was actually prepared at the time that this theft was discovered. Mr. Otto's own handwritten notes contemporaneous with that list. Those coins are not on this list. Why would Exhibit 2 include those items? Because the prosecution prepared this list, not Mr. Otto. Mr. Otto testified he doesn't even have his notes from when he first looked at the property in 2016. He couldn't remember exactly what he did in 2024. Luckily, Mr. Fry had the actual copy in Exhibit 4 of what he provided to Mr. Otto, and that shows those coins weren't even on there. Picture, Judge, that you are advising a client. Picture your private practice days, and a client has retained you to advise them on the purchase of a business. They're doing their due diligence to buy a business. And you're given a document that looks very similar to Exhibit 2, and it's got a list of the business for sale. It's got a list of the assets from 2016, 2024, 2025, 2026. Looks like a lot of valuable property on that balance sheet. But because you want to do a careful job for your client, you want to actually talk to the expert that prepared that balance sheet. And what you come to find out is pretty alarming. You find out that actually that expert who you're interviewing, the company's accountant, didn't prepare this balance sheet. The company's lawyers did. You also come to find out when you're asking, okay, so where did you come up with the value for the property that you have on this list? The expert says, well, I looked it up on the internet. I looked it up on eBay. What is selling for on eBay? And then you come to find out that on this balance sheet, there's actually been items added to the list of property that weren't in the original list. You go back and look at, okay, well, let's prove to me that you that the company's assets in 2024 included these, two most expensive items most valuable items on here, and you get the actual list, and it's not even on there. And then you talk to the expert even more, and you find out that the expert is not licensed to value this property. The accountant is not licensed to value the property that this company is trying to sell your client. The expert admits they're not qualified to even give an opinion on some of these things. Now, your advice to that client would be to run for the hills because something fishy is going on with this business. Something fishy, someone is trying to sell you a bill of goods. The reason why it doesn't sit right with anybody and why it was so shocking that the final number submitted to the court for restitution almost quadrupled from what was proposed, what was set forth in 2024 is because there's something abnormal, something that's not right here. We've got a list of property that was prepared by the prosecution and given to the expert weeks before the restitution hearing. The expert didn't prepare Exhibit 2. Mr. Otto didn't prepare Exhibit 2. He didn't check his notes. He didn't check Exhibit 2 against his notes to see if it was accurate. He didn't even have any notes. He didn't even know he had any notes until Mr. Fry produced Exhibit 4. And Exhibit 4 doesn't match Exhibit 2. In fact, Exhibit 4, which was made at the time of the theft, before anyone had pled guilty to anything, before there was even an arrest. Exhibit 4, to me, Judge, is the most reliable piece of evidence, the most important piece of evidence that was presented at the restitution hearing. After almost 4 hours, we didn't get the actual truth until the very end of the hearing, which is that the value of the property that Mr. Fry believed was stolen amounted to $44,350.21. And that list of property did not include the gold Krugerrand coins or gold Canadian maple leaf coins. The addition of those items in a list of property prepared by the state that the state's own expert didn't even review or compare to his original notes, that doesn't line up with the original notes, should be completely disregarded as unreliable. and objectively unreliable evidence. So, Judge, the number that I would propose, the number that I think is supported by the truth, is $36,626.60. And that's crediting Mr. Otto's valuation from June 9th, 2026 for everything except the gold Krugerrand coins and the Canadian Maple Leaf coins. And that's me giving Mr. Otto credit for his reputation as a outstanding businessman of high integrity and honesty in the community. That he looked at these items and gave it his best shot based on his experience to value those items. And if we look at total all those up, it comes out to $59,343.60. And then we turn to Exhibit 1, which is the value of items that were recovered by Mr. Fry. The total amount there is $22,717. Subtract that from the $59,343.60, and you get $36,626.60. That's
Can you repeat the number? Because you said 59,000, and in my calculations, if I'm just listening to your argument, I only get 53,812. What was your calculation?
So I took I'm looking at Exhibit 2. I took Mr. Otto's grand total amount. It's right in the middle of page 2 of Exhibit 2. And if I'm reading his handwriting correctly, it looks like the grand total was $217,012.60.
Correct.
And then I subtracted.
Oh, I'm sorry. I used the wrong numbers because it's such a interesting exhibit. I used the March 2026, not the updated. There's where I went wrong. I now see the difference. Thank you. Sorry, I did not mean to interrupt your argument.
No, that's fine. And I'll just finish, just for the record, I'll just finish that calculation. So I took the $217,012.60. I subtracted the $101,728 for the gold Krugerrand coins and the $55,950.40 for this gold Canadian maple leaves. And I did that correctly. Then the math comes out to $59,343.60.
Okay.
On to the second piece, which is Ms. Honeycutt's ability to pay. I read the state's brief. I understand, the thing that jumped out to me was there's no reason why Ms. Honeycutt could not work more than one job. I think, Judge, I think it's a tough position to be in because you want to make sure that there's repayment and that the goals of restitution are met. And then at the same time, you also want to balance that this is a human being who's got to live and pay for a roof, eventually is going to have to survive on her own and stand on her own when she comes out of prison. And that she's got to put a roof over her head. She's got to put food on the table. She's got to be able to put gas in the car. And live a life. And I think the proposal that we should take into account in the ability to repay analysis that an assumption that someone would work 2 jobs is asking an extraordinary amount from somebody to pay off a debt and to factor into their ability to pay. Why not? Why stop at 2? Why not stop at 3? You should have 4 jobs.
Well, I'm going to say I see multiple people with 4 jobs or, well, at least 3 jobs trying to make ends meet and have a life. So that's a bad argument.
I understand that point. I think that having a full-time, having multiple jobs add up to full-time is not an unreasonable ask. I think full-time in Wisconsin is defined as 30 hours. I don't think that's an unreasonable ask at all. And I agree. There are many people out there that stitch together multiple employers to add up to that many hours. But asking someone to work 50, 60 hours a week and make a payment plan or impose an obligation on them on the assumption that they're going to be working more than full-time, I think is not a fair ask to make of anybody.
Well, the world is making that ask on a whole lot of people right now, Mr. Stroud, a whole lot of people who don't have to pay back restitution for criminal actions just so they can survive. So again, I think that's a terrible, it's not winning me over with that argument.
The other aspect to consider, Judge, and I don't think Ms. Honeycutt is Ms. Honeycutt is coming up from a place where she has a high school degree. She has what I would describe as a spotty work history. And after she is released from Techita, she will have a significant gap in her employment, a gap which is filled by a felony conviction for theft. And I think the quality of work that Ms. Honeycutt, that we can reasonably assume Ms. Honeycutt will be eligible for, is going to be pretty low. It's going to be pretty low. And so I also think that should be, regardless of how many hours we're expecting Ms. Honeycutt to work, she's not going to be making very much money. These are going to be jobs where they are just looking for somebody to fill those roles. And so I asked the court to take that factor into consideration as well. She's going to have an enormous mountain to climb in terms of finding reliable employment. And the court should consider that as part of the ability to pay analysis. I'm not saying she shouldn't pay anything. What I'm saying is that there's a line at which we're asking an extraordinary, impossible amount for somebody in Ms. Honeycutt's position to be able to pay back. So I think the amount that the court finds is due in restitution. I think we need to balance the realistic possibility, achievable possibility that she'll be able to pay things back and be able to take care of herself through work. And I'll pause there, Judge, if you have any questions.
I do not with your argument. Mr. Schmidt. Rebuttal.
So a restitution hearing is not the place where you get to challenge what you pled guilty to. Ms. Honeycutt pled guilty to theft of over $100,000. At the plea hearing, she stipulated to an amount of over
124,000 something.
To the extent that it appears today, she's trying to break her plea agreement. I think she's already stipulated to that amount. And I think that because of the way the restitution statute is written, that the court may order restitution related to any crime considered at sentencing with a nexus to it. I think arguing it should be less than 100,000 doesn't make any sense. I'd also note that Ms. Honeycutt makes a lot of allusion to Exhibit 4 somehow being a smoking gun or strange or something new. Exhibit 4 is literally in the criminal complaint. It's pages 5 and 6, and the criminal complaint also adds, he gave this list and then also said the Krugerrands. The Krugerrands are referenced on page 4. None of this is new or controversial. It's been information available to Mr. Stroud for over a year. His argument is effectively, you shouldn't believe Timothy Frey, the victim, that the Krugerrands existed and were there. That's what I'm kind of hearing. He's saying you should believe Exhibit 4, which is his claim of in a list of estate items that didn't include the Krugerrands.
I'm going to stop you right here with both of the things. To Mr. Stroud and Ms. Honeycutt's benefit, nobody was provided this very strong and very convincing Exhibit 4 to either Mr. Stroud or to Ms. Honeycutt during any process of this matter. But a strength of the state side and the victim side is, and it was stipulated to $124,631.47. So you can argue those things, but for the fact that Exhibit 4 was not provided to Mr. Stroud or Ms. Honeycutt during the whole process of this matter, things could have been different, because I am going to tell you, I do not see at all the gold Krugerrands or the Canadian maple leaves on the very important document signed by the very important expert, Mr. Otto.
Judge, that exhibit is in the complaint. We didn't transpose the language. It's literally a photocopy of Exhibit 4, is pages 5 and 6.
Okay, so let me go.
That's why I'm saying they did have that.
That's in the complaint?
Yes. And the complaint also relates, Mr. Frey gave that, and then he also said, I also lost the Krugerrands as well as the Taurus 9mm handgun. That's what's in the complaint. That's what she pled guilty to, with the theft of over $100,000.
It is in the complaint.
That's why I'm saying it wasn't some strange new missing smoking gun type exhibit.
Okay. Better understand.
So I think that a lot of what Mr. Stroud argued had to do entirely with, Mr. Otto, what Mr. Otto knows. Restitution hearings are not, the trial. Restitution hearings are supposed to be something informal to accommodate the fact that it's supposed to be informal, to be more favorable for victims so that they, without their advanced knowledge and experience, can present a case. The state helps in these cases by helping organize and collect information and presenting it. What was presented is the exact stuff that he presented law enforcement back when this case happened, which is referenced in the criminal complaint. The value of it increased, specifically gold and silver, increased a great deal. Bob Otto testified to that. All the other stuff we did with testimony for Bob Otto was to just demonstrate his expertise and knowledge and how thorough he goes through things, and just that he is an expert. He's an expert by experience, and this is what he does. To the extent of the items taken, it was always predicated on Timothy Frey saying, these items existed, they were stolen from me. The reason I know these specific items were taken is I did an estate. I also knew about these Krugerrands. I think we've met the burden of preponderance of evidence. I think the stipulation to the initial amount, the 2014 amount itself, is itself an admission that these items at these values from 2014 were there, and that Bob Otto testified the value went up. And following the restitution statute, it's the value at sentencing minus what's been recovered in the meantime. I think that the values are very reasonable based on what Bob Otto said, and based upon how him and Timothy Frey explained, we asked these lower, bullion material cost values for assessing the value. And then we did the benefit for removing the things recovered, doing a higher collector's value. They were trying to do conservative estimates, and I think that the court should order that conservative estimate. As to ability to pay, Ms. Honeycutt has many years of work ahead of her. There's no reason she can't pay this. The restitution order is not supposed to be something where, you know, it's supposed to be easy. It's part of the punishment. Thank you.
The issue that I'm having and I'm seeing, and I'm looking that Exhibit 4 was used as an attachment within that criminal complaint, and Exhibit 4 only goes to number 70, and then after number 70, then there's the 71 added. That's not on Exhibit 4. The gold maple leaves, 72 is the gold Krugerrands, 73 is farmland title paperwork. And then there's other additional items below. So you have Krugerrands in there twice and maple leaves twice.
My Exhibit 4 doesn't have 71 and 72.
Yours, or whatever exhibit is, I don't have them marked. I just have the paper. Exhibit 2 is yours. Exhibit 4, I do have it marked. That Exhibit 4 is the one that doesn't contain those. Exhibit 2 does contain those, the one that you drafted or your office drafted. I'm just looking at the criminal complaint where your Exhibit 2 adds on numbers that were not in Exhibit 4 when Mr. Otto signed all of these, and that would be maple leaves, Krugerrands, farm title work, and a handgun. And then I just said, and additionally, you can look in the gold Krugerrands and maple leaves were added twice in your criminal complaint. So
Exhibit 2 is what we actually relied upon. It's what Timothy Frey and Bob Otto testified to is the value as of the day of sentencing.
yes, I get that. I understand that. I get all that.
Mr. Frey testified, you know, when this first happened, he had to scramble to get numbers to the police. He did the best he could. Now, after having the benefit of a year to put things together to do the restitution claim, he put forward the complete restitution claim, minus items that he didn't have documentation for.
The thing that it's hard for me to understand now, because I didn't compare them before, because I wait until all of the arguments to go over all of the things, is the point that Mr. Stroud is making, that on this very important, serious list from the very serious list is not identified with a date, but the updated total is dated March 19th, 2024 of this very serious list of the things that were from the estate and were valued, which do not contain the Krugerrand or the maple leaves. And the very important list is signed by Mr. Otto. And Mr. Otto's testimony very clearly said, well, I don't remember. I don't know what I did. I can only tell you that based upon the original numbers that I'm provided that I think I did, because it looks like I did it. You can tell in how these other things are written. That's how I would have written them. That's what I do. This is my practice. But in the list that he signed, it does not mention Krugerrands or maple leaves at all.
It comes down to whether you believe the victim or not. Timothy Frey testified that these things existed, they were in the safe, and they were stolen. If the court does not believe his testimony meets preponderance of the evidence, then that's exactly what the court should conclude. What Mr. Stroud says, that you should just not believe the victim.
I could respond to that.
Yeah, I might have one more question.
Sure.
No, I don't. You can continue. You can speak, Mr. Stroud.
This is why a restitution hearing is an evidentiary hearing. We don't just fall back onto allegations in the complaint, is because even though it's not a criminal trial and the burden of proof is different, credibility needs to be tested. And the court heard from these two witnesses at length, and Mr. Fry said Exhibit 4 is what he prepared. His list, taken from the list he gave to Mr. Otto in 2016. That's the contemporaneous evidence before anyone was convicted of anything, before there were even any suspects.
But Mr. Stroud, isn't it correct, because this is my memory and I have a pretty good one, that part of the deal was, and it was accepted, and I went over it multiple times, that there's a stipulation to an amount of $124,000, $124,631.47. That's correct, correct?
Yes, there was a stipulation. We took evidence, and I think the truth shows that there's a lower amount. There's a lower
But
amount.
you
of
can't go back
restitution.
on a stipulation that breaks the plea agreement, because that was the plea agreement, correct? So are we going to do all this all over again? Because I'm hearing that this is not correct. Because I took a plea and the state gave a plea based upon the fact that there was at least a minimum stipulation of $124,631.47. Either you're stipulating to that amount and no more, or I'm hearing that this didn't go as planned and that she's kind of trying to jump the plea.
No, there's a stipulation. There's a stipulation. I'm saying
Okay,
the truth.
That's all I need to know, that it's stipulated to $124,631.47 based upon all of the information that was at hand and provided during the discovery, and as stated in the criminal complaint, because in the criminal complaint, it does contain that Exhibit 4, and it does also contain in the complaint that addition of the Krugerrands as well as the Maple Leafs. I understand your argument and your point. I get where you're definitely coming from, Mr. Stroud, and it's a very persuasive argument as it relates to the value of the property and how the numbers were arrived at and actually agreed to in 2024 by Mr. Otto, who very clearly, I recall, stated, I don't really remember. I don't remember these one for one, what all they were. I remember I did it and I went over these things. And then in 2024, I have this list where I increased the values from 2018 to 2024 values. And then I dated and I signed it. Very persuasive argument, but for the fact that there was an agreement reached for a stipulation. So that's where I am. I can't go lower than a stipulation because that was part of the agreement. As part of my agreeing to accept the stipulation to begin with.
And I would add here, the reason why I emphasize restitution hearings are not the place to challenge the factual allegations of the case, and is because, there's no rules of evidence. Hearsay is allowed. It's not presumed that the state's going to be required to bring in all of its witnesses and prove up the case. When a person enters a plea to theft of over $100,000, the state doesn't have to prove that all the items that were needed to prove the $100,000 were actually stolen. To the extent that Mr. Stroud is arguing today, she didn't steal Krugerrands because they didn't exist. Therefore, she didn't even do theft of over $100,000. I think the court should disregard that. Thank you.
Well, they may or may not have existed, but they don't exist from Mr. Otto's standpoint in 2024, which falls back to 2028 or 2018. So that's the argument, but I have other things that I have to consider. Any last words, Mr. Stroud?
No.
Any last words, Mr. Schmidt?
The restitution argument made by the state was never, you need to believe only Bob Otto. There's a reason Timothy Frey testified. Everything the court relies upon for finding any restitution on this requires finding Timothy Frey credible, reliable, and believable. The state thinks he was. If the court does, then it doesn't matter what was on one exhibit versus another.
Oh, it does. It does in all the things. because I do have to look at credibility of everyone who testifies at a restitution hearing. I can believe he is credible on one thing, but not credible on another. I can believe that he is stronger and believable in one aspect, but not in another. As long as I make sure that my words are communicated and they're communicated thoroughly in my order, that's all I need. I don't need to say, I believe him wholeheartedly, he wins 1000%, or I believe Miss Honeycutt wholeheartedly, she wins 1000%. Credibility is not a cut and dry kind of deal. So I have all the information that I need to make a decision. I do have my ample notes to rely upon and all of the arguments. I will get something out relatively shortly. The court, I always say this, Mr. Stroud, the court has 90 days in order to get out a decision. I am far faster than that. It would be 2, maybe 3 at the very most weeks that I have ever taken my time to get something out. All right, if that is it, then we are adjourned.
Thank you.
Thank you.
Have a nice
Thank you.
day.
We will go on the record in the matter 17 CF 194, State of Wisconsin versus Michael Frank. The state doesn't appear, the state is not required to appear. This is a fail to pay case. Numerous warrants have been issued in this matter. This is a 2017 case. Mr. Frank pled guilty and was placed on probation on August 17, 2017. He was ordered to do certain things, ordered to pay court costs and fees in the amount of $443. The court ordered money to be paid towards that. And it hasn't been. He got a warrant in 18. He said he would pay. He didn't. He got a warrant in 19, said he would pay. He didn't. Another warrant in 19, said he'd pay. He didn't. And that's just 2019. And I'm not going to go through all of the years and do all of the things, Mr. Frank, because quite frankly, I don't want to. And it would take too much of my time and too much of my voice. I did waive a lot of the fines and fees, honestly, because I just don't want to deal with you anymore, Mr. Frank. Why haven't you paid the $200 that I was mandated and ordered by the Court of Appeals to order for a DNA surcharge? I waived the rest. Why couldn't you pay the $200? And so I waived the rest back in February of 2026. You did state after the hearing, when I said I would release you, you said that you were looking for a job. You said you had a girlfriend, and I think you were living with that girlfriend. I think the girlfriend was older than you. I'm going to guess 36 or 40. You called her old, but that is not an old age. Are you still with that girlfriend, Mr. Frank?
No, I broke up with her because she tried to shoot me up with meth while I was sleeping.
I mean, that's a good reason to break up with somebody. I'll give you that. So, Mr. Frank, I'm going to guess you don't have a job.
I don't, but I also found out about my dad's house. I have to be off probation and out of jail to sell my dad's house.
That doesn't make sense. That's not correct.
That's what my brother Steve told me while I was in Polk County. He sent me a letter in.
Oh, that's because your brother wants you to do all of those things, all right? That's what your brother wants. The law doesn't care.
That's what they said. That's what he said was in the will per what my dad put in there because I was the one taking care of him.
Well, then that's your dad's will and your dad's thing. But does he know you?
Who, my brother?
Your dad.
My dad, he's dead.
I know,
But
but
yeah,
he obviously knew you, so he put that in. He wanted to have you do better. He wanted you to stay out of trouble. He wanted you to stop committing crimes. He wanted you to not be on probation. He wanted you to not do drugs. He wanted you to get a job. That's why he put that in the will. And honestly, again, I don't care. I don't care about the house. I don't care about those things. You needed to get a job. You needed to do something, and I need $200. So how am I gonna get $200, Mr. Frank? Because again, I waived a lot because it originally was, I think, up to $700 around there. It was $688.50. I waived all but $200, Mr. Frank, all but $200. How am I going to get that money that I can't waive, that the Supreme Court has ordered that I shall and must order with each conviction, and it's not waivable? How am I going to get the money?
I don't have any way to pay it.
Well, I don't have any other way to go about this. What I'm going to do is I'm going to order that you must sit. Well, how long have you been in custody?
I've been locked up since February 11th. I got revocated.
Not with me.
Well, so Monday of the 6th.
Monday of the 6th. And so, do you see why your dad put that in his will? Do you understand that? He's afraid you're going to dissolve and thrift away all that he worked hard to earn and to buy a home. Why were you in custody in someone else's care for 7 months?
Because I got revocated.
All
on
right.
probation for the charge when you guys picked me up in September of last year, you made me miss court and polk. So
I
closed
made
that.
you miss court.
Well, no,
I
I'm not
made
saying
you miss court. Maybe your actions and conduct made you miss court, Mr. Frank. I did nothing. Neither did the law enforcement officers. Neither did the state. We did nothing. You did all the things, correct?
Yep, whatever.
Okay, yep, whatever. So, you were revoked off of probation in Polk County?
Yep.
You have open charges anywhere?
Nope. I'm pretty
Well, I
much
guess-
done with Wisconsin.
Excellent.
I have treatment lined up at the Burkwood House when I get out.
Excellent. Court is going to order 60 days of jail, finding you in contempt yet again for failing to pay your fines and fees. I'm ordering 60 days of jail starting July 6th, when you were picked up from our ill-gotten silly actions of picking you up on the warrant. 60 days. And then I'm going to order, once you are released from custody, if you do not pay the $200 I'm going to give you, so July, August, September. I'm going to give you until December 15th to pay $200. If you fail to pay $200, the court will issue a warrant against you. You always owe this money, and the court, you could sit up to 6 months in jail. Do you understand, Mr. Frank?
Yep.
December 15th, $200. If by some chance you can beg, borrow, or plead for $200 from any friend, family member, or significant other, then you can bail out early. Once you pay, so it's 60 days or pay and you can be released. Otherwise, it's 60 days jail. And then once you're released, full payment of $200 by December 15th. Again, if you don't pay by December 15th, another warrant will be issued and we will be right back where we are here today. Do you understand?
Yep.
Because again, this is going way back from 2017 when you were convicted and the court did $443 in fines and fees, then other fines and fees were added. It increased to $688.50. In February of 2026 here, the court did waive everything but the DNA surcharge. And still no payment, not one payment since 2017. All
Can I
right,
ask you-
thank you.
Can I ask you a question?
One
How come
question.
how come you guys don't send anything to collections in this county?
Because I like to collect. It's my favorite thing, and this is why I like to collect. Do you understand?
Yep,
Yep,
Thank
I'm
you.
not like any other county, so don't count on that. Thank you.
yep, bye.
Brandon, Dearest, Armante, Brandon, 267-246-588. You don't want to sign the advice of your name? You're the one who smells like the weed, huh?
I grow.
You grow. Good. Well, listen, I'm not going to play games with you. If you can't read, that's one thing.
Yes.
You can't read?
No, I'll take a turn.
Okay, good enough. Your attorney can go over your rights with you.
Thank
Tell him you can't read and you're going to go over he's going to go over the rights with you. Shoot, I don't know who you have to say. We'll give him, you'll get that lawyer, you can go out the hallway, talk to him or her, and then you'll come back in front of you.
It's not nuanced, it's a lot. That's what we're pleading to them. This is the same. This is the same. That's what I said, yeah. The problem is, he told me, I'm not just showing you how to do this and this. That's why I never listened to the concerts. They're just signed off on the team. That's why I think about it. I just, you know what? Yeah. I'm not talking about council. Here we're talking about that. Sign off on the ticket saying dismiss. Dismiss. All right. Yeah, but I've been before it was. I just talked. Yeah, told to be here. I told him my ticket says $10. It is a submission. Then I said, I need to swear out here. And they said, no, moved it to one. I said, yeah, you moved it to one. Yep. I get no notice saying we moved it to one. Either. So 1 o'clock, okay. So I came back over 1 o'clock. What's 3 o'clock? Almost a whole day of that. Supposed to dismiss it. I have to go to them. I want to be dismissed. So I'm going to do that. I don't care what they do. That's supposed to be kind. Elderly and mature. Those are the two things that America said. Elderly and mature. Attack when you get old, try to take your license, put your homes, steal your houses, car, anything, work, and it's if you're a child, they come and try to steal you from your parents, said, yo, let this, and what they for, honey. They're trying to go, so you'll trap me. I see your son again, you might not. Okay. Still in the system. So they said, my system, you can't find them. All they do is they wait for someone to get into it with the factors. It's at the elderly lady or elderly man, building hospital, make them sign a waiver now, or they say the doctor, oh, they swung on me. So now they're committed to the shop. They're strapping down. Now the hospital got permission to basically take over the parent. So now it's all for money. It's all for money. It's all for the trust. There's the trust here. Social Security trust fund. We're all trust fund babies. So they just have to make the trust. That's it, bro. No, not even the cash. Nah, he can't. He's a little boy. He like girls though. I know that. They can't tell me to come out that way. Which is only like something. That's about on these little kids. You tell me I've said something. This is how they do it. And they can't. They divide everybody. So everybody, they want to be us to say something different. Really, yeah. Just like the dogs. There really ain't no different dogs. There's all the dogs. There's different breeds. Dog and the birds, just different breeds. Well, so there you go. Oh, yeah, but yeah, I see the owners know. Yeah, exactly. That's what's there. My ski tribes, so look at the trees. Trees. You know, they really need a bunch of contracts that get violated. They would not watch it. Anything about it. For a whole thing. You're a piece of metal. It's not real.
People against. Brandon, Darius Armante Brandon, file 2-6F-246588. Your name?
There's someone there.
Are you telling me you can't read?
Oh, Your Honor, Peter Bernardo, P78413, MIDC counsel for Mr. Graham.
For purpose. For purposes of arraignment, does he see any way formal reading?
Yes, Your Honor.
Now he's going to plead guilty to allowing an unlicensed driver to drive.
Yes, Your Honor.
Did you graduate high school?
Okay.
If you plead to allowing an unlicensed driver to drive, possible penalties are up to 500 fines, 90 days jail. Costs are all of those. Did you cover his rights with him?
I did, Your Honor.
Did you read this advice of rights?
I read the advice of rights to him, yes.
Did you understand all of those rights?
Layman's terms, no, but it's okay. I just need to get this done. I have a son, whatever. Yeah,
You didn't understand the rights?
sorry.
It's okay. I gotta explain it to you. It's all right. You're presumed innocent. Do you understand that?
That's what I thought. That's why I came in. I ain't gonna lie to you. I came within my ID. That's what I came to do. I saw all. I'll show it.
I don't know. You just kind of wanted to be belligerent here today, right?
Just wanted this.
You come in, you smell like dope like I've never smelled in my life at any point. Not when I was in high school, college, at 67. I mean, you got the whole building reeking.
Work at a facility. It's the only job I eat for my ass.
Listen to me. You are presumed to be innocent. You understand?
Yes, you do.
You have the right to a trial. At a trial, you have the right to bring in your own witnesses. You have the right to use the subpoena powers of the court to bring in those witnesses. You have the right to testify or remain silent. If you remain silent, the jury would be told they can't hold that silence against you. You have the right at a trial to cross-examine their witnesses, to bring in your own, to use the subpoena powers of the court to bring in your witnesses. If you plead guilty, you're giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, Sean.
You understand everything I've said?
Yes.
If you plead guilty, I'm going to dismiss the original charge of driving while suspended, and I'm going to accept your plea to allowing an unlicensed driver to drive, and we're going to sentence you. Do you understand?
Yes.
To the charge, allowing an unlicensed driver to drive, how do you plead?
Yes.
Were you in control of a 2008 Chevy that was being operated on Arsenal near Matilda and Flat Rock, June 24 of 26?
Yes.
Do you allow somebody to drive it was unlicensed or suspended, and was that you?
Yes.
Are you on probation or parole?
No.
Anybody forced you to plead guilty? Please accept that the suspense dismissed. I'm going to go on to these others. Try to go and console your son, and I'll call you next. So go take care of that, and I'm going to go on to another case. Jalen Gerald Carter, 23F 240. Your name?
Jalen Carter.
Counsel?
Good afternoon, Your Honor. Peter Bernardo, P78413, MIDC counsel for Mr. Graham.
This is where you plead to no ops, suspend to be dismissed, true?
Yes, Your Honor.
If you plead to no ops, possible penalties are up to 100 fines, 90 days jail, costs are all those. I'll then dismiss the suspend. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form today? You guys gotta have these rights forms. Geez, you know, you gotta have these forms signed for me. I mean, if the guy can't read, that's one thing. You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial by court or jury. You have the right, you enjoy the presumption of innocence. You enjoy the requirement that the people have to prove your guilt beyond a reasonable doubt. You have the right to cross-examine witnesses, bring in your own, use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all those rights. We're not going to have a trial. Do you understand that?
Yes, sir.
To the charge, no valid operator's license on person. How do you plead? Were you operating a motor vehicle in Gibraltar near Olmsted and Flat Rock, October 18 to 23 at 9:51 p.m.?
Yes.
Did you have a valid license then on your person?
No, sir.
You don't have one now either.
No, sir.
Are you on probation or parole?
No, sir.
Anybody forced you to plead guilty?
No, Sorry.
What do you, anybody force you to plead guilty?
No, sir.
I'm accepting your plea or no ops, dismissing the suspend. What's holding them up here?
It's just a matter of money, Your Honor. He's been in touch with each one of those jurisdictions, that if there's 19 or 20 total, and that, at least 19 outstanding tickets he's got on payment plans on every single jurisdiction, and this is the last.
Where do you work?
AT&T.
He's
What
up
do you
in
do?
the wage, $50 an hour. Bro, how many hours a week do you work?
That's not much. How old are you?
I'm sorry.
How old are you?
Oh, I'm sorry. 27.
And you're only working 30 or 33 hours a week?
I'm in grad school.
Where are you studying?
I'm working my master's in cybersecurity. I did my undergrad in GDS.
You're going to get your master's? Yes?
Yes, sir.
And you're conducting your business affairs like this? I hate this. You don't have to apologize. If you intentionally didn't show up, you must have 15 or 18 warrants on here.
Not anymore.
He's on payment plans, Your
Yeah, I'm
Honor.
on big points.
Let me see. Your record was run on July the 8th. Okay? This is the 14th. Have you been to Southfield?
Say it again.
In the last 6 days, have you been to Southfield District Court?
Not in the last.
The Romulus District Court?
No,
The 36th District Court?
no, not in the last 6 days. No.
The Dearborn Heights District Court?
No.
The Southfield District Court, you already said you haven't? You haven't been to Dearborn Heights? How about Ferndale?
No.
Then you haven't taken care of any of these. This lien was run on July the 8th. Why are you coming in here telling me not anymore? Not anymore. You sounded confident, like I can run up Mount Everest on my.
I am confident, sir. I'm put down payments on this.
You got warrants out for your arrest. You might be paid. They might be letting you pay on them, but you have warrants all over. All those places I just mentioned. And they were not, Detroit had about 6 of them. Southfield had 2 of them. Dearborn Heights had 2 of them. And I'm just questioning why somebody that's smart enough to go get a master's would conduct his business affairs like this.
Well, I mean, sir, I did what I was told. I was told to pay what I could, and just that I could go and pay less every 2 weeks. That's what I could do.
Let's just stop this conversation. Because I'm going to get agitated in a second. I don't want to get agitated. It's been a long morning, long day. You're not telling me some judge over in Southfield, when he issued the warrant or she issued the warrant back on November 8th, 18, said, don't worry about it. Pay it when you get around to it. If it's 2045, we're good with it. Did anybody tell you that?
Tell me.
I don't want to hear what they told you because so far I don't believe anything you're telling.
Sir.
Go ahead, Mr. Ganato. I mean, it's nice they're giving him no ops, but he doesn't deserve that. But that's neither here nor there. Go ahead. Tell me what you want to say.
Your Honor, all I have to say is that I believe that he was aware of, if not all of them, most of the wants and warrants out on that he's made a, concerted effort to try to get them cleared. He wants to get this all behind him. And I believe that, based on his fact that he's mostly a student, and he's only working 30 hours a week at minimum wage or just over an indication that he is under some financial hardship and ask the court to consider that and pass the sentence.
Anything you want to say, sir?
No, sir.
Still can't condone. I still cannot condone your inaction on all these for this long. 100 fines, 250 costs, 75 victims' rights, $50 justice assessment, 475 or 90 days. How much do you have today? You pay 50 now. You pay 50 per week. I won't start this until August the 21st. If you do need more time, it's not a problem. You call the court, we'll go on Zoom. I'll be glad to give you an extension. You just got to come in and talk to me on before the due date, okay? You can either come in person or on phone where we set you up on Zoom calls, okay?
I'm sorry, I didn't hear that total though. Could you?
Sure, it's 475.
Oh, thank you.
So after you pay 50, you'll owe 4.25.
Okay.
Good luck to you.
Thank you.
Darius Armonte Brandon, 26F, 246-588. You can just bring him up here, sir. I'm just gonna sentence him now. Your appearance?
Peter Granada, P78413, MIBC Council, Mr. Brandon.
Your name?
There's somebody, Brandon.
No, he doesn't have a horrible record. Anything you want to say?
I believe that, Mr. Brandon has got some money to pay today, and he'd like the opportunity to be put on a payment plan to get the balance off.
Anything you'd like to say? Hard fine, 70 costs, 75 victims' rights, $50 justice assessment, $295 or 60 days. How much do you have today? You pay $200 now, and I'll just give you until August 1st to pay the rest. Is that fair? That's another 95. If somehow you don't have the money, call the court, we'll go on Zoom. I'll give you an extension. I wish you well.
I'll borrow the rest from him right now, so I don't have to deal with it.
Good luck.
Okay, thank you, Jim.
Why'd you come back in there with your hat on when he told you not to have your hat on?
Oh, sorry, sir.
All right.
Let's get Glimp going. Ms. Horn, have you talked to Officer Denon? He's here for Glimp. Let's call it.
I did,
ready, Ms.
Your Honor.
Let's call it. Mr. Barry, Glimp. This is the city of Detroit versus Rubinoff Valentino Glimp Jr. I said that sounds like a superstar name. Case number SP 189-23641. Appearance for the record, please.
Tamika Horn on behalf of the city of Detroit, P70303, Your Honor.
All right. And Mr. Barry, put your appearance on the record for Mr. Glimp, please. Did we lose Mr. Barry?
Yeah, I didn't hear him put his name on the record.
I think we lost him. Ms. Jenkins, can you give me a second? I'm asking you to do double duty right quick. Can you put your appearance on the record for Mr. Glimp?
Yes.
All right. Appearance for the record, please.
Good morning, Tana Jenkins, on behalf of Mr. Glimp. Sir, your name for the record?
Rubinoff Valentino Glimp Jr.
All right. Today is the date and time set for a trial. I did have Officer Denon appear. Can you speak to Ms. Horn? What is the offer?
It's a 3-month delayed sentence, and that's actually a reduction from what he wanted to offer. So that would be the offer for today. He is available by phone. I can jump on right now.
So that means he would have 3 months to pay a fine, and so long as he pays the fine and doesn't get any new misdemeanor charges within that time, this offense would be dismissed from his record.
Yes, ma'am.
Okay, so Mr. Glimp, here's the deal. I'll give her a few minutes to get the officer here if you want to exercise your right to a trial. If you want to take the deal, you can take the deal. If you want to speak to Ms. Jenkins in the breakout room regarding all that, I'll absolutely let you do that. What would you like to do?
Okay, yeah, because I don't want to take that deal at all.
Say that.
I don't want to take that deal. I don't want to take that deal at all, Your Honor.
All right, Ms. Horn, get Mr. Denon back. I'll give you 15 minutes to get him back in here. We'll pass the matter, and I'll give you an opportunity to speak with an attorney.
Okay. Thank you.
Mr. Barry, there? No,
yes,
Mr.
Your
Barry's-
Honor.
Mr. Barry, put your appearance on the record for Mr. Rubinoff Glimp.
Elwood S. Barry Jr. on behalf of the defendant, Glimp. You want to state your full name, sir?
Yeah, I just did, Mr. Barry.
He did already. So, Mr. Barry, here's the deal. Mr. Glimp wants to exercise his right to a trial. He was afforded an offer, 3-month delayed sentence, pleading as charged. $240 would be the fine. Give him 3 months to pay the fine and not get in any trouble. The case would be dismissed. He indicates to the court that he doesn't want to take the deal. I've given the city attorney 15 minutes to get our officer back in here, and I'm going to pass the matter, okay?
Yes, Your Honor.
Thank you.
Are we ready on Glimp?
I like stuff I'll be watching every day, I guess.
Are we ready on Glimp, Mr. Barry?
Ready, Your Honor.
All right, let's go back on the record with Mr. Glimp. Ms. Horn, can you put your appearance on the record, please?
Yes, Your Honor. Tamika Horn on behalf of the city of Detroit, P70303. Officer Diamond is here and available for trial, Your Honor.
Officer Dinan, good morning to you.
Good morning, sir.
Turn your camera on, please, and state your name, badge, number, department for the record, please.
Police Officer Michael Denon, badge 2545.
All right, good morning to you. Today is the date and time is set for a trial, and Mr. Glimp wants to exercise that right. The burden is on the people. Ms. Horn?
Yes, Your Honor. And let me take a look, if we could take just a quick 1 minute recess, Your Honor. Officer did send me a message. Okay, and Officer Denon, we can probably reissue.
That's fine.
Yeah, today was a little crazy anyway, but Your Honor, on behalf of the people, we are moving to dismiss. At this time, Officer Denon is unable to access his camera footage, and we believe that it would be a waste of the court's time and Mr. Glimp's time and Mr. Berry's time to go forward when we don't have everything we need right now.
Case dismissed, Mr. Glimp. If there's nothing further, have a very good rest of your day.
Thank you, Your Honor. Thank you, Mr. Berry.
Okay, and thank you, Mr. Glimp, and that is without prejudice, Your Honor, with stipulation to probable cause, counsel?
Yes.
Well,
What does that mean?
that means, well, let him know what that means. First of all, the without prejudice means that they can rewrite the ticket and come back again on it. Secondly, the probable cause means that Officer Denon had probable cause to stop you.
So, well, I was just standing on the side of my house. So you said he had probable cause to pull up on me?
That's what that would mean if you
Okay.
if you that.
Okay.
So will you make that stipulation or not? That's up to you.
Mr. Glimp?
Oh, it's up to me to make the stipulation that they can bring it back up, because I don't want them to be able to bring it back up.
Well, that's going to be my determination of that.
Okay. I'm sorry. I misunderstood.
That's going to be my. But do you agree that Officer Denon had probable cause to pull up on you?
No, sir, I do not.
All right, so he's not stipulating in that. As far as the prejudice argument.
Our argument, Your Honor, is that the facts of the case and the evidence has not been put on, it has not been adjudicated, and therefore, if it should be decided, often we do not, the case will be reissued, and then Mr. Glimp will have his right to trial again, in addition to the evidence that would be available to him if he'd like to review any video or documents.
And what is the court rule that, is there a court rule that says that I'm obligated to give you a without prejudice?
I believe so, Your Honor. I don't have that on me. I did do a motion on that before in another matter. The court did not respond, but with prejudice means that it was adjudicated on its merits.
What do you have to say, Mr. Berry?
Well, I'm going to say I'm not familiar with the court rule regarding the court's obligation. But it would be interesting to know what was the basis for actually issuing the ticket.
Let me see the court.
And the court rule that the people are citing for purposes of research on the fly right now would be Michigan Court Rule MCR 2.504. Also says involuntary dismissal, Your Honor. A judge may order an involuntary dismissal with prejudice as a sanction if a party fails to follow court rules, fails to prosecute their case, or violates the rules of civil procedure. Generally, as I briefed before, it's based on the merits as far as all elements of the case were not met by the prosecution and warranting a dismissal.
Oh. No.
Okay.
All right, in reading this, in reading court rule, dismissal of action, voluntary dismissal effect by plaintiff, by stipulation, substitute the provisions of MCR 2.420, MCR 3.501E, MCR 2.420 has to do with settlements and judgments for minors and legally incapacitated individuals. That wouldn't apply here. MCR, the court doesn't believe that would apply. MCR 3.501E is has dealing with class action suits, and dismissals or compromise. An action certified as a class action may not be dismissed or compromised without the approval of the court and notice of the group. That wouldn't have any effect here. This is not a class action suit. An action may be dismissed by plaintiff without an order of the court and on the payment of costs. That's Section A, by filing a notice before the service by the adverse party and an answer. There was no answer in this case, or by filing stipulation of dismissal signed by all the parties. Otherwise stated in the notice of dismissal or stipulation, the dismissal is without prejudice, except that a dismissal under subrule A1A operates as an adjudication on the merits when filed by a plaintiff who has previously dismissed an action. That didn't apply here. By order of the court, Section 2, except as provided in subrule A1, an action may not be dismissed at the plaintiff's request except by order of the court on terms of conditions the court deems proper. If a defendant has pleaded a counterclaim, that didn't apply here. Unless other order specifies otherwise, a dismissal order under subrule A2 is without prejudice.
Your Honor, in response to that, I usually use the scale form, and that's 1, 2, 3, 4, 5. We can't dismiss if there was a motion or another filing made by the defendant. Or after that, if so, we have to stipulate.
Understood.
Yep.
So you want the court to, you want to be able to have the right to bring back the case, and why are we not ready to go now?
We can go now. We can go now. I mean, I just was communicating with Officer Denon, and did we need to communicate again, Officer Denon, or?
No, it's okay. The only thing I would just input, Judge, is that I don't have access to the video right now. I would just be going off my recollection, so some things would not be able to be recalled.
All right, that's up to you and Ms. Horn, Mr. Glimp. If you want the dismissal without prejudice, is that still on the table or what?
The people are moving to dismiss without prejudice, and the people will defer to the court as to with prejudice.
May I speak with my client, Your Honor?
Well, go ahead, speak with him momentarily and then come on back, Mr.
Momentarily.
Yes, sir.
It's already been, I've already heard enough argument. I was gonna rule it on it anyway.
Okay. It's too much.
All right. I'm gonna dismiss the case with prejudice. Mr. Glimp, have a very good rest of your day, sir.
Thank you, sir.
It's over,
All
Mr.
right.
Glenn.
Thank you.
It's over.
Thank you, Officer Denon.
Officer Denon, be safe.
Thank you, Your Honor.
Ms. Jenkins, I think you can go ahead and get prepared with Ms. Graves. I think that's a good time now.
Judge, would it be possible to print out the jury instructions or somehow, I would like her to be able to look at those.
I am going to forward you what I was sent from the city.
I have that. I guess I could show her on my computer.
This is 60 some odd page, 65 pages.
Okay. All right. Thank you. I will sign off and come in.
Very good. Do you want me to print it out for you? Would that help you better? Whatever needs to facilitate you to get this this done quicker.
I'll come in. I'll ask and I'll come in. I'll be there in 1 minute.
So you do need to go over there. If you have anything that you would propose to change in them, then we'll allow you to speak on that. So I will print this out. And then it's already see one thing, it's in the first one, it's the jury of 12, but as you know, this is a misdemeanor, so there are only 6 is only so this little things like that probably need to be addressed. Listen, she comes in here with all of this, what I call nonsense of filing abatements, and I don't know what she wants to do. We've offered her an offer. She did not accept the offer. And with all of this abatement, and I'm not appearing on behalf of Destiny Graves, I'm protecting this court because you're not going to come back. And I've already filed grievances filed, I believe, against me from Mrs. Destiny Graves. So I'm giving her her full right to a jury trial. If she wants to take an offer, she can take an offer.
Okay.
But if other than that, this whole abatement thing and all of these documents that she's filed, the court doesn't understand that. And we've had conversation after conversation about this.
I don't want a grievance either.
Well, I mean, you know, so, and again, you are not, listen, why don't we just let her proceed on her own? That would be the best thing to do, because I do not want to put you in this situation either. And I should not have asked you that. And I apologize. So Ms. Graves, you have a copy of the jury instructions. You can go over those jury instructions. If there's something in those jury instructions that you want to address the court and say that I want to not have this in these instructions or something, then you can address the court and we'll deal with those accordingly. If you want to take a deal and you don't want this jury trial, you can take a deal, but that's going to be up to you. Okay. So why don't just, I really do apologize for putting you in this situation. You know, I do appreciate you coming in outside of that to do that, but let Ms. Graves, I've given her an opportunity to get an attorney. I've given her all the opportunity in the world. So I don't know what else the court can do in order to make sure the process is fair to her and the court is protecting itself.
I understand.
All right. Very well. Ms. Graves, are you sure this is what you want to do? Huh? Positive. Be $145 fine. It doesn't abstract to the Secretary of State, therefore it doesn't carry any points. We'll close it out after $145 fine. All right.
Is there anything for
Give me a basis. Just because it's Ms. Graves. Let's call it City of Detroit. City of Detroit versus, did she fill out an advice of rights? But I guess if it's civil infraction, it's fine. I do have an advice of rights in here. City of Detroit versus Destiny Graves. Case number SP 1902232, counts 1 and counts 2. SP 1902234, counts 1 and counts 2. Appearance for the record, please.
The city of Detroit, P70303. Officer Del Zacchio is here in the building and available for trial today.
I did see him. I have him marked as appeared.
Thank you.
For appearance, please.
Hannah Jenkins, PA2663, on behalf of Ms. Graves, I did have an opportunity to speak with her, and she has asked me to represent her.
Absolutely.
Sorry. Oh, Tana Jenkins.
Step up to the microphone. It's probably.
Tana Jenkins, PA2663, on behalf of Ms. Graves, I did have an opportunity to speak with her. I know she previously indicated that she wanted to represent herself, but she asked me to represent her today. She is here in court. What is your name for the record?
Step up to the microphone so she can get it clear, please.
Destiny Rice.
All right. Today is the date and time, and it's set for a trial. We were scheduled to have a jury trial. You understand it's your right to have a trial by jury, correct, Ms. Graves? And you understand that you the offer is pleading to an expired plate civil infraction, and it's $145 fine. It will not abstract to the Secretary of State, and the other matters will be dismissed upon stipulation of probable cause. You understand that, ma'am? All right. And you want to take that, step up, say, you have to talk, and you got that, Miss?
No. Just get close to me. Yes, thank
You got that?
you. Yeah.
All right. And you want to take that deal, ma'am?
Yeah.
On behalf of your client, Ms. Jenkins, you stipulate to the face of the ticket as an accurate factual basis for that responsible plea?
Yes, Judge.
You stipulate the probable cause for the dismissal of the other matter?
Yes, Judge.
With those stipulations, I'll find your client responsible as charged to the expired plate, and I'll dismiss the other matter. Go ahead, Ms. Jenkins. Why should I give Ms. Graves a break? Let me let the record reflect that Ms. Graves' mom is here. The court does recognize that, ma'am, and the court does appreciate that for the support of your daughter. Absolutely.
Judge, Ms. Graves is a young woman, you know, many times young people are of limited income. She is employed, but she also has a young daughter for whom she provides financial support. I know she was previously experiencing housing challenges.
I know all of that.
And so she's definitely someone who is trying to earn more, and she's a smart woman, and I know she will earn more, but at this point in her life, she's of limited means, and so we're asking that fines please be waived.
The issue really is, Miss Graves, it just bothers me. And I'm not gonna hold this against you for any fines and costs that your counsel has asked me to waive for you. But it just bothers me that you take the time and the court has no issue with filing motions. The court has no issue with any of those things that you want to exercise your right. This is what we're here for. But you take the time and you file these things. I don't know where you learned this from or got this from, but the court has no basis in law at all. I would suggest that whomever you have got this information from and you've been dealing with this, and I can only imagine you got it from someone, that you need to stop listening to that person, take yourself to law school and go and get your own law degree. Because what I do recognize in you and what the quality that I do recognize in you that I don't see a lot of in attorneys is that you're persistent and you want to be heard and you're going to make sure that you're heard. That's a good thing. But when you're trying to speak, you have to speak in terminology that the court understands. And this whole stuff about abatement and things like that, the court you've done this before. And the court has no understanding of this. We operate off of these Michigan court rules, the Constitution of the United States, and the Constitution of Michigan. You see how big these rules are? Nothing in those rules, in these rules are that you file or in that documentation. So about giving you an opportunity to, about giving you a chance to pay this and to not pay it, I'm not going to grant that. There's got to be some kind of punishment, because what I see and what I believe is that I believe, well, one thing, Mr. Graves did get a valid driver's license last time.
Excellent.
And I was very surprised about that, because she was pushing this narrative of this abatement and all of that stuff, what I call sovereign citizen stuff, the last time. And then lo and behold, I see Ms. Graves again. And I'll see her again, I believe. I do believe I will.
She's going to law school, Judge. You won't see
Well,
her.
until you may.
So I do want to say that I respect the court, I respect you, and I understand that you look at the way that I go about being in court as sovereignty. I understand that what I state isn't recognized in the court. However, I also do understand my rights, and I know I have to stand by that. So me standing by my rights is in no way, shape, or form to disrespect you, to disrespect the court, or make you even feel like I'm being irresponsible. The way that I see it is me being irresponsible and me holding other people responsible. Not saying you, but we all have a job to do. You have a job, the bailiffs have a job, the officers of the court have a job, and the officers, outside has a job as well. The officers who stopped me has a job as well. I'm not here to blame anybody. I never was. That was never my intention. My intention was to simply stand on my rights and protect myself, as you will be doing the same for the court. So that's all that I really wanted to say. Like I said, I respect the court and I respect you as well.
Well, I must say this, and I do find it a little bit disrespectful at times when you continue to push those things. And I've already ruled on those things. When I rule on something, your right is to fully go to the next level and appeal my ruling. And to and if I got it wrong, that's what how the system is. You do not continue after I've made my ruling and I've given you opportunity to put everything on the record, haven't I?
Yeah.
I've always given you that opportunity. You do not go and challenge my ruling by continuing to push the same thing that you've been pushing. What you do, if you do not like my ruling, you take my ruling to the next court and appeal my ruling. That's how the process works. The process, you're not going to get anywhere by continuing to say, are you going to let me be heard on my abatement after I've let you be heard on your abatement? And I've told you your abatement, I don't recognize that. I don't understand anything of what you're saying on that. So again, this is why I am fining her the $145, because there's got to be some sort of punishment in this, because you are still, what you said, standing on your rights. So I still believe that you don't feel that you have to have plates on your vehicle. You don't believe that you need to be driving around in a registered vehicle. You don't believe that Officer Zacchio wrote you those tickets in. Can you stand up, officer? Can you state your name for the record, please? Did you get that, or does he need to step up to the podium, please?
Please step to the side.
Officer Del Zacchio, Detroit Police Badge 706.
And good morning to you.
Good morning.
And I do say he was here on time in the beginning. So that is why what you just said is that you're standing on your rights. Go ahead.
I did have an opportunity to confer with Ms. Graves. She is going to put plates on her car. I think what she's standing on the rights of all people, because the social system is broken and she's advocating essentially for change and equality. There's a lot of racism in policing. There's a lot of disproportionate minority confinement. There's a lot of brutality, and she recognizes this. And this is her effort to change that. And she does believe that the system is broken, but she is an intelligent woman and she is going to maneuver within the system while still doing what she can to advance change. And by that specifically, she is going to register the vehicle if she hasn't already. And I think this idea of law school is perfect for her because we need spirits like hers who are truly dedicated to change and dedicated to equality and dedicated to eliminating a lot of the racism and other oppressive elements that are creating inequality and still operating within the system. And I think that this has been a powerful moment for her, and we're grateful to the prosecutor and we're grateful to the court and we're grateful to everyone else in the court for the patience.
And let me say something to you. I have the same skin complexion as you. I understand that it's not always fair and the system's not always fair, especially because of the color of our skin.
Yes.
There's no getting beyond that right now, but we are all expected to play in the rules. Never once have you said that this officer was unfair to you because of your race. Because had you said that, we would have addressed that issue too. I have never had anybody come in here and say this officer has done anything because of your race. I respect the fact that you say the system is broken, and I understand that the system is an imperfect system. And we're probably will always be an imperfect system, but with people and advocates like you can be properly, you can help to balance the system out. That's what I try to do on a daily basis as well, because I'm not going to allow somebody to any of these officers in any way to run over your rights because of the color of your skin. But you do need to operate in the system. If you don't like it, part of it is going to the legislature, and part of it is exercising your right to vote. Part of you may want to consider being some sort of getting involved in politics to help write that system. We do need better people. We need better lawyers. But the way you go about doing things is not recognized in the court of law. All right. So I hope that you take this. This is the second time we've been down these roads. I was very pleased and happy that you got, first of all, and first and foremost, your housing. That was the most important thing that I can see. Second of all, you did get a valid driver's license, and it blew me away. I was surprised. Now I would like you to, hey, we'll give you a copy of the court rules. As a matter of fact, here, give her that. All right. That's a 2005 copy. I'm sure that not much has changed in that. 2025, take that. You can start with that. My brother told me before I became a lawyer, I need to read every page of that. And I did. Did I remember every page? Probably not. But I do know how to find out where to go to get the information. All right.
Judge, this is very expensive.
Your Honor, on behalf of the people, I thank you for doing this. For Ms. Graves here, I was just telling her mom, my daughter has a similar name as her middle name, and they always call her Mom. I'm like, yeah, she's fine. But I'm really proud of you. That's a good book, because I think that in government we get those free every year. That's a good book. That it's only a year old. Nothing's changed, and I do feel for you. I didn't want to go to trial on North Fireplace, but you got to get your plate. That's
call a jury and
I
tell
gotta
them.
pay for insurance, my plate, and
email.
I can't insurance, so I know your position, but I have to pay it, so squeeze it out of somewhere. About $15 to pay it. So I understand.
Can I just say something? I did not experience.
Step up.
I did not experience any like racism or anything with the officer.
Huh? I know you're just talking generally about the system. I get it. I just want to make sure that we're all clear and all on the same page. And I just wanted to make that clear. But and lastly, this, you know, I really like the way you present yourself. I do like the way that I want to see more out of both sides of the attorneys. My job is I want to see good lawyer. I want to hear good arguments. I want you to put me in the position that I have to make the decision, because I hate ruling against any side too much. I wish everything could work itself out, you know, but I know that they can't, and I do have to make a decision. So you take knowledge of those things. Well, first of all, and then let me talk about the insurance. I say it, and I'll say it on the record. I'll say it so everybody here. I do believe that the system is against Black people. I believe that the rates of the insurance are too high in the city of Detroit, one of the highest in the country, because we are taken advantage of because we are an all-Black city.
Yes.
I do believe that.
Facts.
I do believe the power of the insurance company now, while I do understand that insurance is important, because if you hit someone, this other person is injured, somebody's got to be taken care of. But the power that they can compel everybody to have insurance, that's a very powerful power. And the only ticket, well, I won't say the only one, but a no insurance civil infraction, that $45 reinstatement is probably one of the only reinstatement fees at this time that will suspend your driver's license. Maybe on a reckless driving, $45. I got it. Maybe on something like that, but that's a powerful lobbying system that is able to make sure that our legislator in 2021 says we're not going to recognize any $45 reinstatement fees, although you have to pay them. You're not going to recognize that as a tool to suspend your license, except for no insurance. That's powerful.
It is powerful. I've had cases where people have fled the police because they didn't have their license because it was suspended because of no insurance. And they ended up going to prison for multiple years. So the consequences are.
Yeah. The judge knows as a prosecutor, I avoid that charge.
I do. I will say, Ms. Horn does take into consideration, we look at document tickets. These are document tickets. Nobody said that Ms. Graves went over the speed limit. Nobody said anything like that. Now, you could have gone over the speed limit. That may be why you got stuff. I don't know. But nobody wrote you a ticket for these. Are just document tickets, and they're saying that you don't have your proper documents. So, Ms. Graves, there is a lot that the system needs, but the system needs good advocates, and in order to be a good advocate, you have to play by the rules. And I know the rules can sometimes be stacked against you. Trust me, I understand that. But at the end of the day, you got to fight, and your mom told us you all got some fight in y'all. You and your sisters, right, Mom?
Yes.
All right, so put it the right way. All right, you're gonna pay this $145. I'll give you opportunity to get on a payment plan, or you can do community service. What do you want to do? Well, see, so you want to pay? She got money. I'm gonna give you until August the 13th, 2026 to pay it. Pay it at any DivDat kiosk in the city of Detroit. I'm told you can upload the DivDat app to your phone. I thank you, Attorney Jenkins, and I appreciate Attorney Jenkins advocating for you not to pay the fine. That's what she's supposed to do. But in this case, she didn't win this one. All right.
Thank you.
Best of luck to you, Ms. Graves. Thank you so much for sitting in with us. I hope you enjoyed your day. And have a great Officer Del, I will see you soon. I always see him out there. All right.
Wow. Judge Perkins said a lot of stuff there that me, myself, as a citizen of the state of Mississippi, can't really have much of an opinion on, but I do pass the question off to you. And I do beg you, use the comment section down below. Let me know all about what you think Judge Perkins had to say at the end of that court case, which was seemingly the conclusion of a very interesting, what started off as a sovereign citizen case that old Squishy Gardner was covering all along the way. I knew her as the chapel gal, and she was kind of weird. She was housing challenged for quite a while. I don't want to get into all of it. We had quite a few interesting cases today, starting off with Judge Stewart. You know, I really need to read these super chats over here before I get too terribly distracted. Dear God. So much that could be said. So many interesting cases. Late and emotional baggage fee from Scott McIntosh. Thank you so very much. Where's the money, Lebowski? You know, you're not sure. We may never know. How many licks does it take to get to the center of Tootsie Roll top lollipop? Tell me. Some people say 3. Dude, you have to cuss so much. What the are you talking about, man? I'm not actually gonna cuss. I sent a little quirky message after that. Thank you so very much for that super chat. One last donation for the night from Darth Steven, the objectioner. Thank you so very much, Darth Steven. And thank you so very much to old Squishy Gardner for coming out and hanging out tonight, talking in the chat, watching that crazy case that he is the one who turned us on to all that long time ago. God, I don't even know. It's been almost 2 years. It's been dragging on forever. Forever, man. And hey, what can you say? Judge Mogen's stuff too. That gold digger. I just think it's funny. I know it's low hanging fruit, but it's kind of true. She dug up some gold. God only knows what happened to any of it. No, I don't know if any of it was ever recovered. We may never know. And the guy who doesn't pay his fines, yeah, and she gave him a hard time. Judge Dad is always disappointed about something. I don't think anybody. It's very rare that we actually get to see people come in front of Judge Dad and actually, you know, impress him. It happens. It's not often. We see Judge Dad mad or disappointed more times than we see him pleasantly surprised. That needs to change, ladies and gentlemen. All you people out there in Woodhaven, make your dad happy. We like to see Judge Dad happy. Kind of cool. Don't forget, we'll have more. Same Wolf time, same Wolf channel. For now, I'm your lone wolf Usul, the guy who puts all this stuff together. And I'm saying ciao. I am out.
Meow.
And remember, only you can take a bite out of crime. Bye!
Meow.